in the 10th century, in the Abbasid period, siyasa is being seen as a legal rubric as well, as a way in which, to encompass all the military and administrative protocols and actions that are distinct from fiqh. And so siyasa is not just for criminal justice as well. They're using siyasa for the madhalim, they're using siyasa to refer to taxation, for the vizierate as well. And sometimes they'll say that these are established practices that go back to earlier periods, including late antiquity as well. But so what Mawardi does, throughout it, he doesn't, throughout his section, in Abu Ya'la's section on criminal justice, they don't discuss generally what they'll say the Qāḍī and the Amir. And the Amir has to establish reasonable suspicion based on information gathering. He doesn't need witness testimonies. They state that outright. He doesn't need witness testimony. And if it's established that the person has a criminal reputation, or he's found with, some evidence, he's found with a picket to rob something as well. We can move on to the next stage, which is the interrogation stage, and we can do darb Tazir, which is a discretionary beating as well. And so what you're kind of seeing here is that they're not coming up with these concepts. They're really the first ones to kind of stay outright as jurists and judges that, okay, there's two different spheres of law under Sharia. There's the ahkam, which are the religious ordinances, and there's the siyasat, the protocols, or the governmental actions that the Amir has to follow. And the Qāḍī follows ahkam, religious ordinances, which he's kind of saying that's religious tradition, that's fiqh.
Peace, everyone, and welcome to the Real Talk Podcast. I'm Terron, and as always, I'm joined by my brilliant co-host, Roxanna. Today, we're diving into some truly fascinating research on criminal justice during the Abbasid period, a time when military and administrative practices significantly shaped the concept of justice in unexpected ways. We'll explore what these practices reveal about the interplay of power, law, and governance in early Islamic history. And to guide us through this intricate topic, we're thrilled to introduce Dr. Mohammed Al-Lehbi. Dr. Al-Lehbi is a research fellow at the Oxford Center for Islamic Studies and specializes in law and governance in the Islamic Near East and Mediterranean during Late Antiquity and the Middle Ages. Today's podcast is inspired by his 2022 article, "It is Permitted for the Amir, but Not for the Qāḍī," which explores the origins and rationalization of coercive practices in Abbasid criminal justice. Assalamu alaikum, Dr. Al-Lehbi. Thank you for joining us. We're thrilled to have you on our platform to discuss your research and its broader implications.
Thank you for having me.
All right. And just to get started, Dr. Al-Lehbi, your article sheds light on a lesser discussed aspect of Abbasid criminal justice. What drew you to this topic, and why do you think exploring the role of coercion in Islamic governance is important for understanding the development of law and authority in the early Islamic period?
So I was drawn to this 12 years ago when I did my master's at University of Chicago. I was originally going to do something on the Soldiks, and one of my professors, Paul Walker, at the Center for Middle Eastern Studies, was like, maybe you should read this text called Al-Muntazam fi Tarikh, written by Ibn al-Jawzi, who is this 12th century historian, jurist, religious scholar. And so I'm reading this chronicle, this 18-volume chronicle, and I keep seeing that criminal cases are being judged by the Sahaba shurṭa, ostensibly the police chief, and not the judge. I'm like, that's weird. Why? Where's the judge in all this? Why is the police chief the one judging these criminal cases? So that made me go into a rabbit hole and trying to figure out the criminal justice system. And so why was I drawn to coercion? So there's something very interesting about coercion. Coercion is a topic that has three central themes. Violence, the violence of the state or any authority, to maintain its control or principles through a monopolization of violence, and coercion is like coercing a population or subjects to submit and obey. But there's legitimacy as well. Is this violence legitimate?
Mm.
You know, is it legitimate based on ethics? Is it legitimate based on principle? Is it legitimate because the ends justify the means? And then what's truth as well? How do we get to truth? Do we get the truth by somebody making a statement? Can we even trust their statement? Do we have to put pressure for them to give the right statement? Is compulsion something that actually affects the truth as well? And I think all these three themes are revolved around coercion, especially coercion as an evidentiary tool in the criminal justice system.
And for listeners who might not be familiar with the Abbasid period, could you just briefly explain its historical significance and why it's such a pivotal era for understanding Islamic governance and law?
Roxanna, you're asking me a really difficult question to really break this down, like this whole period, but I'll try. I'll try. Okay. So I'll give the boring answer first, and I'll give the more exciting answer. So the Abbasids were this clandestine Arab Muslim movement that successfully in the 750 toppled an empire, the Umayyad Caliphate, and they took control of territory ranging from present-day Pakistan to North Africa. But at the same time this was happening, there was a separate revolution. So the Abbasid period is foundational and revolutionary. So as they're doing this, the tribal structures are starting to give away in what were previously garrison towns, like these tribal military towns in places such as Iraq. So you have cities like Basra and Kufa by the late 8th century have population in the hundreds of thousands as well. And and the Abbasid capital, Baghdad, is also the city that, like, by the 10th century, a conservative estimate is 500,000.
Mm.
And we have this cosmopolitan culture that is like this fusion of Hellenistic, Persian, and Arab Islamic. We have these translations done on Greek and Sasanian texts, on politics, um, on mathematics, on philosophy. So the normative and institutional roots of Islamic civilization, like much of Islamic civilization, is being established in this period as well. The four Sunni schools of law emerge in the Abbasid period. Sunni, Shia theology, Shia legal methodologies are being emerged as you have these jurists trying to interpret religion and establish legal methodologies as well, based on religious tradition and the legal frameworks that they're trying to establish. At the same time, institutions of justice are being established as well. The judiciary and the criminal justice system, the shorta. And we also see that there's a separation in legal spheres. There's a separation between what I would call a religious jurisprudential sphere of law and a governmental sphere of law. And this is starting in this period as well. So for us to really get into, the early forms of Islamic governance and law, which will shape societies even after the Abbasids for centuries, all the way up till today.
Yeah, and that's one of the things I found so interesting about this period of Islamic history, or even just within the Abbasid history, is that there was a division between the religious sphere of jurisprudence and the and governmental authority. When my understanding is that they had always been together from the beginning, and I'm pretty sure we'll get to that later. The
Yeah.
rise of the ulama in the Abbasid period. But just to go back to coercion, how do we define coercion? I mean, what is defined as coercion? You mentioned violence. Is that always the case? Can there be other methods of being coercive where you're not violent? And how did it become a recognized method in Abbasid criminal justice? What made it a distinct form of legal principles outlined in fiqh, or distinct from the legal principles outlined in fiqh?
So all good questions, and I think it's like, for me, I got to answer this by stages. So coercion. So it's very interesting. It's like when I was writing this article, one question was, what's the difference between coercion and torture? There's like a really thin line between the two. And I think coercion is, this is like, torture is like, you know, using maximum violence on a person, right? Like, to the point that they're going to be compelled. Whereas in coercion, it can be, it always has to have violence is always there, but it's whether it's a threat or whether it's being implemented.
Mm.
So intimidation, threats of violence, imprisonment, and, any physical pain such as beatings. And so you had jurists, particularly Hanafi jurists, say that anything that compels a person to do an action, such as divorcing his wife, or killing someone, or making a false statement, or converting to another religion, or actually giving a confession for a criminal act. They all label this as coercion. Um, but what was your second question again?
What made it, how did it become a recognized method in the Abbasid criminal justice system?
So I think the thing is that it's all, this is all has to do with the transition from the Umayyad and Abbasid period. So I just to give the listeners just some information on the Umayyads. So the Umayyads were the rulers of an empire before 750, stretching from Spain to present day Pakistan, and they considered themselves as the heads of the Muslim community, and they reigned over through tribal and military structures as well. And the governors and the shurṭa, who are elite military commanders, I'll define what they are later, but they're using coercive methods. So they're using excessive beatings, they're using imprisonments in order to suppress discontent and rebellion, or even crimes as well. And also they're using coercion as well to punish government officials as well, and also extract wealth from them. And so it becomes a military administrative practice. And when the shurṭa become the criminal justice system, it's not surprising that coercion, this established military administrative method, would become a part and parcel of the institution of criminal law.
Okay, so you've sort of suggested, you've explained how the shurta sort of held substantial jurisdiction over criminal justice in these formative and classical periods of
Yeah,
Islam.
yeah.
Could you explain exactly who they were and why has their role been so minimized in Islamic historiographical studies regarding the legality of coercive interrogation and other aspects of Islamic governance?
So I think the problem is the shurṭa, its meaning changes so many times, and I think that's partly the difficulty. But I also think there's a modern back projection as well. So in the Arab world today, like shurṭa means police. So it's like when people read this, they're like, oh, they're just police forces. They're military police forces. But then when you start to really closely read the material, you start to find out, no, this is a much more complex phenomenon. So in the Umayyad period, so in the 7th and 8th century, according to literary sources, but also a few government letters, the shurṭa are the elite military commanders. They serve in the vanguard of the army, but they also serve as the caliph and governor's military deputies. So they're responsible for performing the orders of the caliph and the military elites, and punishing whoever they want to punish. And it's pretty clear, starting from the 8th century, that major crimes or any rebellion or heresy is under the governor's and shurṭa's jurisdiction, even before the Abbasid period as well. And even in early Abbasid jurisprudence, they're discussing about what is the jurisdiction of the shurṭa as well, and they're already saying that they're prosecuting crimes. But so before the late 8th century, criminal justice was shared between the judiciary and the shurṭa as well.
Mm.
Like we see that like actually being mentioned as well. So like the governor and shurṭa are the military elite, so like a military justice system that's over criminal law, and the judiciary as well, who are basing themselves on tradition and religious jurisprudential frameworks. And so what happens in the late 8th century is these elite military commanders become criminal magistrates and police chiefs. Like the Abbasids make this decision. And in Baghdad, we have like this stratified criminal justice system. So you have the Sabi shurṭa on the top, his two lieutenants on the eastern and western side of Baghdad. Under them are district commanders, and under them are watchmen as well, and then prison guards. So it's like a merger of rapid urbanization with this government need to control cities as well. And they're just using the practices that they deal with, dealing with rebels or anybody opposed to government authority is being directed to urban crime at this point. But also at the same time, up until the 10th century, they're still like the caliph's military deputies as well. So for example, the Abbasid Caliph Al-Ma'mun selects the shurṭa to deal with the mihna, the Inquisition, not a theologian or judge. So it's like the notion is they are the extension of the caliph's authority over any legal matter. And then with the diminishment of the caliph, they become more criminal magistrate and police chiefs and less caliph military deputies as well.
Okay, so let me just understand this correctly. The shorta were the ones orchestrating the Inquisition that happened under that Ahmed ibn
No,
Hanbal.
it's the caliphs do it, but Al-Ma'mun tells the shorta to dictate, deal with its prosecution. So he gives the reign of the prosecution to the shorta, of course, to follow his orders, but yes.
Gives an extension of his authority to
Yeah.
implement. Okay, interesting. But yeah, and it's funny that I've never heard of this term, the Sahib al-Shorta, even mentioned within that context. Like Roxanna mentioned, it seems like they've just been mysteriously vanished in Islamic history.
And I think, well, so the thing is, it's not that they're vanished. People keep talking about them. It's just, I think the historiography, there's two issues. One is that we don't have sources written by the shorta. So we don't have like direct, there is material. There's a lot of material, but we don't have direct sources on the shorta. But there's also a perception that they're military policemen. They're not legal actors. Or they're acting in extrajudicial ways as well. Like they're not legitimate. They're not legitimate actors and authorities of law in Islamic law. And my argument is that actually, no, because I view this through a legal realistic lens as well. If it's being enforced, it's law, and that these, just because that they're distinct from the fuqaha, the jurists, doesn't mean that they don't have their own legal logic and legal methodologies as well.
Which obviously they did, and you touched on why it was why coercion was seen as a practical necessity for the shorta, given rebellions and just the needing to police such a vast empire and consolidate authority. I mean, and how did this align or conflict with? But how did this align with or conflict with Islamic legal principles? And building on that, what role did fiqh play within the imperial government? Since you talk about there was a divide, and how might it have clashed with the practical demands of administering such a vast empire? Like you would think Islamic fiqh, all the volumes of books out there on it, that they would have had something to say about administering such a vast empire to where government authorities wouldn't have had to rely on the the logic of the shorta in order to keep things intact.
So, Terron, one thing I'm going to push against is practical necessity. It is there, but I don't think it's necessarily a cynical use of power. I think what's happening is that there's a continuity. And so in the article I discussed the first Muslim chief Judge Abu Yusuf, and it's like his horror at all the excessive beating, the coercions that are happening in these prisons, and he's saying this is illegitimate, this is unlawful. But I think they thought it was totally legitimate and lawful. I don't think they thought to themselves, oh, we're breaking Islamic law. They were like, we're authorities of the caliph, the head of the Muslim community as well, and we're just employing the practices that we've learned from our previous military commanders, these are established practices. So I think the thing is that there is a pragmatism, but it's wrapped around this notion that no, this is the way we do things as well, and there's nothing illegitimate about them. Now about Islamic legal principles as well. So this is I think because I think that they are following Islamic legal principle. It's just not the principles of the jurists,
Of the jurors.
of the jurists, And I think what's happening, and uh, you know, we have to understand what's going on. So, in the Umayyad period, the a large amount of the Arab population were tribal military, like warriors. Okay, and then what happens in the 8th century, due to a lot of rebellions in Iraq, Basra and Kufa, major garrison towns, are demobilized. And the unintended consequences of that leads to the emergence of cities and schools of law as well. But that also leads to a population that's kind of separate from the military class
Mm.
as well. And then by the Abbasid period, more and more of the judiciary is coming from this non-military jurists. It's not coming from the military anymore. So you already have this kind of separation. You have this military administrative perspective, and you have a religious jurisprudential one as well. And I think that the jurists feel this, so Abu Yusuf, when he's talking about this in his Kitab al-Kharaj to Harun al-Rashid, the Abbasid Caliph, in the late 8th century, it's clear that he's like, we can't intervene, like the judiciary and the jurists can't. I want the shurṭa and the caliphs to follow fiqh,
Mm-hmm.
but we're not going to be involved in fiqh. And the question is, did the caliphs and military elites attend this? They intended that they would separate the jurists from fuqaha, or is it's because of the way in which these social and political changes happened? Because it's like they're using the judiciary to administer the empire as well.
Right.
But there's certain fields like taxation, like criminal justice, and even the madhalim, the higher court for prosecuting government abuses as well.
Mm-hmm.
Even that, or even like the vizirate, that seems to be under its own military administrative protocols that are distinct from fiqh. And so I don't really have a precise answer for this because they don't say it. They don't say outright why this happens. But what's clear is that even like the fact that you don't hear mentions of the shurṭa that much in fiqh. They talk about it, but they don't really, they always say the judge is the one who's a legitimate legal actor for judging crimes. Even though we know that the shurṭa are the ones
Right.
judging crimes. So
I
I
mean,
think
so
that,
would this be like an example of, or some kind of example in some way, shape, or form as a separation of church, so to speak, and state in Islamic history? Would you say, I've asked one person and they said, no, they don't see it as, or they don't see this whole thing with siyasa and fiqh as a separation of, I hate to say, I mean, you know what I mean when I say church.
I know what you mean. I know what you mean. So actually, I would say yes and no. So I think there is indications that they did see.
Because then you see,
They did see it
that
that
you
way.
see siyasa as that siyasa is still kind of being seen as falling within Islamic principles.
Well, so here's the thing is that I think we have to be careful about like secular sacred discussions because they
Right.
both thought all of them they all like the caliphs and the jurists both thought that like they were the caliph thought the authority was given to him by God. And the
Right.
jurist is like it's this religious knowledge that we get from our for our interpretation and also these traditions as well that we've gained on what Islam is and what Islamic law is. But I think that it becomes much more complicated when you see adaptations of Sasanian Hellenistic political concepts as well. And when you see, like, for example, the famous translation of the Ahd Ardashir, this Persian text that says kingship and religion are twin brothers. So
Right.
there's like a separation, but they're intertwined with one another. And there's like in the 10th century at least, they start saying siyasa and fiqh or siyasa and sharia or siyasa and sunnah. They're already doing dichotomies already as well. And I think the difficulty is the fact that I don't think it's always monolithic. And I don't think normative is ever monolithic, but I think there is an institutional separation, definitely, between the shurṭa and the judiciary, and that the shurṭa are performing military administrative actions that are distinct from the legal methodologies of the fuqaha.
So in terms of just trying to claw our way back to maybe the origins of this, what pre-Islamic late antique sort of Near Eastern practices could have influenced the Abbasid system, and was coercion sort of standard in pre-Islamic Arabian law, or was the way Muslim empires practiced it a very new adaptation?
Yeah, because I
So
just to add, because you did mention that, this whole coercive, actions in extracting information from, the criminals, so to speak, was like understood as, this is just how things were. But then also in your article, you mentioned that like there's no example of these kind of actions in pre-Islamic Arabian law, which I just found, if you can explain that.
yeah, so what I would say is that so based on Hoyland, your first speaker or second, I'm not sure actually.
I would have to go back and look at my
Exactly.
catalog.
But he on his in his study about like, the pre-Islamic tribal past, when he's looking at the law, he says that like criminal like legal cases was based on oath, was based on ordeal, and based on evidence. He doesn't mention anything about coercion. And I kind of believe that because, coercion as evidence seems to be more of an imperial administrative phenomenon as well. An imperial military administrative phenomenon, and less to do with something that's coming from like a tribal context as well. But so how does this coercion really emerge? So Thomas Segoric, the late Thomas Segoric, referred to an Islamic late antiquity as well. Islam is part of late antiquity,
Right.
and so if we think about the fact that the Umayyads and the Abbasids are emerging in this milieu, that's the same culturally and politically as the Eastern Roman Byzantines and Sasanian Persians as well, who also used coercive practices in criminal justice as well. It's not surprising that, and these things are intertwined, right? So it's like if you have governments being dictated by military administrative practices, and you have previous empires doing that, you're going to see this alignment as well. So it's not like that, oh, just because the Sasanians and Eastern Romans do this, Muslims do this. I mean, while Halak took issue with Patricia Crone's notion of like the origins of Islamic law through Roman history, but I think the thing is like if we see an administrative continuity, it doesn't have to be necessarily that like they could be either adapting, they could be either borrowing and stuff, but we're saying that like if they're in the same region,
Right.
that's not surprising that there's this evolution.
Right. And that's one of the things that really enlightened me about your article is that you always hear Muslims took from Roman and Sasanian administrative practices as if it was just like a one-to-one take. But in the example of the shorta and what you mentioned in your article with the rescripts that were going on with
Yeah,
the emperors and the Byzantine emperor, even though
yeah.
you do see a continuity, it's not a one-to-one
No,
continuity.
it's not. No, it's not.
And
It's not. So
so,
they're adapting it in terms of Arabic Islamic norms
right.
as
And it's
well. Like,
because it's something that I'm pretty sure if it wasn't an Arab Islamic empire that had emerged, any
yeah.
empire that emerged would have adopted these kind of administrative practices.
Well, think about Roman law. Roman law, has, coercion, and think of the empires that came after it as well. Like, for example, the Visigoths in Spain, so the Visigoths use coercion as an evidentiary tool as well. And its use exists in, medieval France and England and medieval Italian city-states as well. They're using coercion as an evidentiary tool, and also kind of rooted in the notion of that you can only use it to, you know, lower social people from lower social strata. You're not going to be using it to, noble people, because these people are always going to be under suspicion. Because they don't have, because of their status and their breeding. Of course, they're not going to have the same ethical standards as someone from the nobility, right? And so and you see an adaptation of that of sorts in the Abbasid period.
Okay, so how does the Abbasid approach to coercion compare to the criminal justice system of the Roman, Byzantine, or Sasanian, which preceded it? Since we're on the topic, in what ways was the Abbasid method of coercion, even in social hierarchy, how were they different?
So the thing is, first of all, the social hierarchies are different. Like, like the Abbasid period, there isn't like nobility, but there's like notables or people from good families or people who are known in the neighborhood of having a good reputation as well. Uh, but there's like actually they're also developing their own criminal classifications as well. We see this in the literary sources, about, slaves or people who are, tending to the bathhouses or gamblers as well. So it's like, it's not just simply they have to be from the lower social classes, but that's part of it. But also
Yeah.
that there's actually a distinct classification that they have. What's kind of interesting as well is,
Which seems no different than today.
yeah, it's
Considering
not.
like if you have a bad rap sheet, I understand that if you are like if you have a history of criminality in this period, the shorta definitely would apply certain practices on you that they wouldn't towards other people who
Well,
didn't.
but even if you didn't have a criminal reputation, so it's like it's criminal reputation, but it's also your social status as well. So it's
Like
like
if you were
even
a eunuch or something, they
yeah,
had no problem
yeah.
administering. Which
Well, it
okay,
depends on what eunuch you are. If you're a royal eunuch, you got no problem,
yeah.
obviously, right?
And still, some would argue that maybe that isn't too different than today. If you have a criminal background and the police get you, they might not be as gentle with you as, and maybe if you're of a certain ethnic background, it could also be different.
And one thing too that this makes it kind of ironic is that from the second half of the ninth century to the 10th century onwards, most of the shurta are from Mamluks. So like they're
So they're
freedmen,
from
they're
the
freedmen,
slave.
they're freedmen, they're freedmen. They're not, so it's very interesting that they're prosecuting on these social hierarchical and like ethical like notions that like they just got to the Abbasid Baghdad, like they're being brought in and stuff. So it's very interesting that that they adopt this, right? They adopt these completely different social hierarchy and cultural values that's very different from the places of origins.
Mm.
So
And
if we
also the
can't,
fact that they're, oh, sorry,
no, go ahead.
Roxanne.
Sorry.
No, I was just saying that, and it's also ironic because they have servile origins, and yet they have the choice in who to prosecute as
And they
well.
still choose to prosecute people who may have similar origins to them and no different.
Yeah.
Yeah, it is.
So if we can't sort of find a one-to-one sort of example or of coercive interrogation in pre-Islamic practice for Arabian people, can are there any sort of social or political changes in sort of the emergence of the Islamic Empire that we can link to the emergence of coercive interrogation as an Islamic governmental practice?
Yeah, so I kind of alluded to this earlier, but so what's really happening is the fact that instead of like a tribal military unit where like the population are all part of military elites as well, by the late 8th century, most of the population are non-military as well, and you have a very small military elite, first that they're in like the Abbasid period, they're Khorasani Arabs, basically, and then it shifts and then it becomes like Iranian Khorasanis, and then it becomes Mamluks as well. So you have what's kind of interesting is the military elites, the overseers of the criminal justice system are completely distinct from the rest of the population
Mm.
as well. And at the same time as well, one thing is urbanization. So it becomes really difficult to prosecute crimes as well. And the fuqaha even they say that if you can't get testimonies, you can't enforce the prescribed penalties. Stipulate the ones such as amputation for the hand for thievery or whipping for fornication or even anything to do with, teleonic justice, like, eye for an eye, or it's like you need testimonies. So the challenge is information gathering as well. But at the same time, it's that dealing with urban crime like it's a rebellion, like it's a challenge to authority that has to be suppressed as well. For the authorities, it's like, well, if you're committing crime, you're bringing disorder, right? You're bringing disorder, and so why should you be treated like people who are submitting to the rule of law, right?
And moving on to key figures in text, who was Ibn Wahb, and why is his 4th century treatise on the role of the shorta in criminal justice so significant? And how does his work expose the hierarchical nature of Abbasid society?
So what's interesting about him is that he comes from a family of secretaries and government officials. His grandfather was a vizier for Abbasid caliphs. Uh, at the same time, he's also what's interesting about him, he's a she scribe, actually. Although that doesn't really. So I'll tell you something interesting that wasn't in the article because I couldn't get time into it. But he incorporates like Sunni. He discusses like Sunni and Shi'i fiqh as well, like when he's talking about blood money. So it's but nothing to do with coercion. So he is also a disciple of Ali bin Isa, an Abbasid vizier. And originally, like the work that he writes, Al-Burhan fi Wujuh al-Bayan, is seen as it's actually like at first people thought it was just a rhetorical treatise, and they attributed somebody else, Qudama ibn Ja'far, another Abbasid high official. Like the first half is like a rhetorical treatise. The second half is like an administrative manual. So it incorporates, kind of like the knowledge. And it's like one of the 3 texts that are written in the 10th century with chapters dedicated to shurṭa. So the other one is the anonymous Siyasat al-Muluk, and the other one is Qudama bin Ja'far, Abbasid high officials, Kitab al-Kharaj as well. But what's kind of interesting is that this text is the only one to actually state outright coercion is an evidentiary tool of the shurṭa, and actually explains it. Explains it saying that, well, unlike the Qāḍī and the Sahab al-Madhalim, the shurṭa has its own methodology. And coercion is one of these methodologies. And you would not be able to extract evidence from thieves or other criminals without this. And if an innocent person is going to be harmed, that's just the way it goes. That's like, you got to break some eggs, right?
Yeah, right.
But he's also saying that this is agreed upon by the senior members of the administration as well. And this is happening at the same time as when government officials and viziers, like in the first half of the 10th century, are getting tortured, between like administrative rivalry, and the shurṭa involved in the torture of these people as well. So it's like, coercion is in the mind of these people. But I think what he does well, Ibn Wahb, is that he puts a name. So the thing is, like, Abu Yusuf, when he's dealing with this, there's no counter response to what he's saying. He's saying this is unlawful, illegitimate. It's, and so they're just performing these practices, and with the fact that they're legitimized by the authority of the caliph or governor, right? That's the implicit understanding which Abu Yusuf is trying to combat in the late 8th century. But Ibn Wahb finally kind of says that, okay, actually, this is legitimized by the jurisdiction of the institution as well. Like he's finally explaining this, justifying it in a legal sense as well. Like, oh, the Qāḍī has to use witness testimony, but for things where there's things about doubt, where you need to prosecute people with really reasonable suspicion, you have to use coercion as well. And so I think that's the thing that he contributes as well. Like, before Mawardi and Abu Ya'la in the 11th century, he's like the first one to actually state outright what is the legal justifications for this practice.
I mean, and I found his treatise, or what I understood from it based on your work, pretty convincing. I mean, if you have certain elements in society who criminal elements in society, and they boast on fighting against coercive measures or resisting coercive measures, or they have like a no snitching type of mentality, yeah, you might have to resort to certain, and so, yeah, I found your article really opened my eyes to a lot of things, and it's not just such a clear cut like, oh, coercion is bad in every circumstance. In certain circumstances you might, and I also like how, if I understand correctly, it was Ibn Wahb, or maybe not the other figures that, what the jurists do and what the shurta do, in order to extract evidence. You can't, it won't work for the judge, and what the judge
Yes,
does
true.
won't work. So, we
Yeah,
have to
that's
know
exactly what
time
he
and
says.
place.
Yeah, that's exactly what he says. He says that like the judge and the Samadan can't use each other's methods, basically. So the judge uses testimonies and the Sahaba Shurta uses coercion, as well as like kind of like using like trickery to extract confessions as well. Like, good, like the good and bad cop, like routine. I just think of two shurtas,
I mean, and
they're using like,
you had a
you
chance to
know,
pick the examples in your article, but in the examples you gave, they weren't wrong. In their, when they applied.
well, actually, here's the question though. Okay, here's the thing. Okay, this is so this is the thing is like as a historian, it's not my place to give like an like but to say I'm not pro coercion, so I'll just put that out right. Basically, I'm not pro coercion at all. Basically, and I think that's the thing is like sometimes people when we deal with these things because these are like difficult
Right,
and like fraught things that people are like, oh, are you trying to be? No, I'm not trying to be pro coercion. I'm trying to understand this. I'm trying to understand why this is happening. But one counter is like, okay, if it's working so well, Abu Yusuf's critique is pretty right. Why is the prisons filled?
right,
Like why, like, and crime seems to keep rising. It doesn't seem to be suppressed. So is it working, or is it the illusion that it's working?
right,
Yeah, as well. And also, what are people's trust in the law if it's being done this way? I mean, I can tell you the shorta were not well liked
I can
by the
understand.
population.
Surprising. Yeah.
uh, I'll tell you, but in the 10th century, the population had to pay a tax for the prisons as well.
Oh,
And the shurta, because of like the financial decline of the Abbasids, they also became tax collectors. So just imagine you're being prosecuted, you're being tax collected, by these people who are generally not from the rest of the population as well. So what do you see? You see prison breaks, you see people burning the headquarters of the shurta as well, and so what happens is, and this is touching on your question about like what are the jurists, how are they dealing with this? So there's actually an attempt to do a reform. They try to appoint jurists to supervise the shurta's prosecution of criminal cases as well. And you see this also in the treatises where Qudam bin Jafar, in his treatise, he doesn't discuss anything to do with administrative and military practices of the shurta. He just kind of like extracts discussions in fiqh about like the prescribed penalties, blood money, and talionic justice, and says, okay, that's what the scribe of the shurta has to know as well. So
mm,
it's like there was like an attempt to really align it. It didn't last. It didn't work, but it wasn't like everybody in like the scribal classes were in agreement about this. There was like a debate, so but about like coercion, and it's also like telling that he's the only one to mention this. Like the other two treatises don't mention coercion
mm.
as well, and it's like there's a thing in the anonymous Siyasat al-Muluk where the author ends his chapter on the shurta and he says, there are certain things I don't want to discuss about the shurta. I just find them abhorrent. I find them abhorrent. So, it's um, I think that's the thing. I think that people really debated the ethical and like practical uses of coercion, but it still continued.
Mm.
Just to try to understand again, sort of the dynamic between sort of jurists and these sort of treatises about coercion. How is Ibn Wahb's understanding of Tazir key sort of unraveling the administrative genealogy of coercive interrogation? And how does it compare to how early jurists originally viewed it as a category of punishment?
So what's kind of interesting, why is Tazir his classification is so key because Mawardi calls coercive interrogations of criminals darba Tazir, so a discretionary beating
Mm.
as well. So he like Tazir becomes transformed, and what my argument is that Ibn Wahb's classification of it starts from like this is the start of the emergence of Tazir as like this separate legal category for prosecuting criminal cases that's intertwined with siyasa, which is going to emerge in the 10th century. So he's saying that okay, Tazir should be implemented on these criminal classes and people under reasonable suspicion. Urban militiamen, shurṭa, gamblers, pimps, and alcohol distillers as well. And
People out past curfew.
yeah, people, well, he like people who are just like, there should be a suspicion under them as well. And it's like, he uses the same thing when he's talking about coercion. He's like, it's with the reasonable suspicion of the shurṭa, right? So there's a whole social hierarchical dimension on this. And the thing is, what's happening is that Tazir, which is a concept developed you know, by jurists to say that, it's a way in which to limit, okay, there's just certain crimes that cannot fall under the purview of the prescribed penalties.
Yeah.
So, lack of evidence or crimes that are just not prescribed crimes, you can put a discretionary beating, but they tried to like limit, like some of them tried to limit it. Some of them said it was like Abu Yusuf says that it's up to the caliph's view, but it shouldn't be more than 70 as well. And what's happening is that the scribal classes, who I'm arguing that, it's like because the jurists are not playing a role as like, legal consultants for the shurṭa, the scribes have to step in. Like they have to like write in these administrative writings, like, use notebooks that they kind of form into Amir princes to say, Tazir, okay, we're gonna adapt it because the realm of what you're dealing with is based on a separate sort of evidence for prescribed penalties. And to be honest, we don't want to enforce the prescribed penalties like all the time, right? Let's throw them in prison. It's like imprisonment seems to have been the punishment that was used the most as well. Or let's discretionary beat them as well. Who are we going to do this to? Okay?
Versus the hudud punishments.
Yeah, both. Yeah, exactly,
Okay.
exactly as well. Which have their own, but they'll still apply the hudud. It's not like just because they don't have the evidence doesn't mean they're not going to apply it. It's just they're gonna apply it sparingly, generally as well as a way in which to.
I mean,
Go
I
ahead.
hate to move like all the way sideways and so far into the future, but that just because I always hear in the Ottoman Empire, the hudud wasn't implemented that much. And I understand the shorta was, non-existent in the Ottoman Empire. I mean,
No, it was. Oh,
it
no, it
was.
was. It just was a different name. It was a different name, but there was,
And
yeah.
so I wonder if that is that why a lot of the hudud, I've never looked
Yeah. I mean, that's the central argument. My central argument is that, is that there's a continuity up until the 18th century Ottoman Empire. So the Qānūn comes from siyasa, right? It's like,
Yeah.
Sultanic law comes from siyasa. Even the institution. So in Istanbul, they have the military at least be responsible for 60% of the criminal justice system.
So
And
people were still
they're
being punished, even if they didn't have their hands chopped off or any other things that you might find that are Quranically supposed to be implemented.
yeah.
Punishments were still being implemented.
Yeah, just discretionary beatings, like, imprisonment. Yeah, they're basing themselves, or what they do is that they actually send them to row the ships for the Ottomans as well. So they're doing that. But there's also another element as well, which I don't really go into, but there's another thing that they do, the shorta, is that they'll offer you repentance. How do you get repentance as a criminal? You serve the administration. You become an informant, you become an auxiliary policeman. It's like, we don't really care about your soul, we care about what you can do for us. So but yeah, there's definite continuity to this as well. And I think it has to do with imperialism, definitely, because the shurta and the Mamluk period, which is kind of a different empire in itself, like, is kind of criminal justice is distributed between different military classes and the judiciary. And then what happens in the Ottoman period is they restore a military administrative system that's very parallel to the shurṭa system as well. And I think it's like this notion of like expansive sovereignty is an essential element to this.
And you highlight that literary narratives about Abbasid and Buyid era historians depict how coercive interrogations were practiced. What do these narratives tell us about how it was? I mean, you kind of went over how it was legitimized and normalized during this period, but what kind of interrogating, what kind of practices of interrogation do we know that they engaged in more than, I mean, we hear about beatings and imprisonment.
Yeah,
But I mean, how was imprisonment used? I mean, we kind of have an idea of how imprisonment is used today,
yeah.
but even just like, was it like, okay, we're gonna keep you in here until we get evidence of what? Did they use it as a way of, okay, we're just gonna leave you in here to die unless you tell us? And even beatings. I mean, did they just
Yeah,
take the body in the back? Rough them up a bit and
yeah.
bring them back, or they don't have cameras to cut those off to kind of, but yeah, I'm very interested in how these things were happening.
Yeah, so the literary sources, I think that's the thing is that like literary sources, of course, it's going to be embellishments as well. But I think that the fact that they're talking about this, they're talking about these things happening, is a way in for us to kind of like extract practices because the administrative manuals can only be used like they don't really go into necessarily the details until Mawardi. Mawardi and Aboyala go much more into details. But what's kind of interesting is like Tabari, Tanuhi, Al-Masrudi is basically like saying, yeah, this is just all happening. Basically, this is all happening, that a thief is beaten and he's like, he's kept up awake, so they're all in a, it's like even like in Masurity's tale, it's like, oh, how do you do the subtle course of interrogations? How do you do the subtle course of interrogations? It's not just beatings and stuff. It's applying the right types of pressure to get him to confess as well. But also Atanuhi, who is a judge. That's the interesting thing about him. He's a judge writing in the 10th century. And he's basically, if you're a boatman or somebody under suspicion, yeah, you deserve to be coerced. But an innocent person, no, no, an innocent person with a good situation. This is when justice went completely wrong as well. But it's like, they what they describe it is that it's like an established practice. Like, when the Sabashurta is scratching behind his ear and telling his lieutenants to hit, the boatmen to confess, as I write in the article as well, or the fact that, you find this in Pubbery's tale. You find this like this attendant of the bathhouse, and you intimidate him. You say you're going to be whipped. You're going to be whipped if you don't confess as well. So I think it's like degrees. It's like you start with intimidation and threats, you know, or at least like the notion that you're going to get whipped or you're going to get intimidated, and either you get whipped or you get imprisoned as well. But imprisonment is a punishment as well. It's not just incarceration. They're using imprisonment as a punishment as well. So, but the thing is, what's kind of interesting is coercion and punishment. They're both using the same tools as well. As it's violent. They're both violent. So one is evidence and one is sentencing.
Mm.
So, I mean, you referred to them both a few times now, but Amoradi and Abu Yalab al-Farah, you argue that the treatises of these two 5th century jurists are very significant and represent sort of the culmination of coercion as an evidentiary method. How does the legitimization of the procedure in their work demonstrate how legal thought developed from sort of the practical demands of criminal justice to sort of a more legitimized juristic understanding of the concept?
So kind of like what's kind of interesting about Mawardi and Abu Yala they're both judges, but they're also part of the administrative circles as well, like in the 11th century as well. Like Mawardi is a political advisor to Buyid Amirs and Abbasid caliphs as well. And so the Ahkam al-Sultaniya, I see it as like, the latest continuation of the books of siyasa. It starts from Abd al-Hamid al-Katib, the scribe of the last Umayyad caliph. He writes the first Arabic marital princes with sections devoted to the shurta. right? And so what's happening is more and more time, like, Abu Yusuf is part of this tradition as well. Like, like we're gonna write chapters on administration. But the thing is, like, while Abu Yusuf is like, actually, I'm gonna try to align this with fiqh. Mawardi and Abu Ya'la, and this is the period of which siyasa, so in the 10th century, in the Abbasid period, siyasa is being seen as a legal rubric as well, as a way in which, like, to encompass all the military and administrative protocols and actions that are distinct from fiqh. And so siyasa is not just for criminal justice as well. They're using siyasa for the madhalim, they're using siyasa to refer to taxation, for the visorate as well, with like, and sometimes they'll say that these are like established practices that go back to earlier periods, including late antiquity as well. But so what Mawardi does, like throughout it, he doesn't like throughout his section and Abu Ya'la's section on criminal justice, they don't discuss generally what they'll say the Qāḍī and the Amir. And the Amir has to establish reasonable suspicion based on information gathering. He doesn't need witness testimonies. Like they state that outright. He doesn't need witness testimony. And if it's established that the person has a criminal reputation, or he's found with, some evidence, like he's found with like a picket to like, like rob something as well. We can move on to the next stage, which is the interrogations stage, and we can do darba Tazir, which is a discretionary beating as well. And so what you're kind of seeing here is that they're not like coming up with these concepts. They're really the first ones to kind of like stay outright as jurists and judges that okay, there's two different spheres of law under Sharia. There's the ahkam, which are like the religious ordinances, and there's the siyasat, the protocols, or the governmental actions that the Amir has to follow. And the Qāḍī follows ahkam, religious ordinances, which he's kind of saying that that's religious tradition, that's fiqh as well. So it's like finally we, like someone from the legal theorists who were so opposed to this for so long, finally actually outright legitimize this as well and say this is like these are two natural branches of law.
I mean, do they consider the ethical challenges? I mean, like, what ethical challenges did coercion pose to these jurists? I mean, did they even consider like, hey, maybe this way of extracting evidence is against certain Islamic ethics? And if so, how did that kind of shape the broader discourse on the whole concept of justice within Islamic jurisprudence?
Yeah, so what's kind of interesting is that Mawardi and Abu Ya'la both say, okay, well, and this kind of actually has parallels to medieval European notions of coercion, is that they'll say, uh, well, if a confession is extracted, you have to wait for a period of time for him to make a second confession, you know? And then so they're uneasy. It's clear they're uneasy about, like about coercion as an evidentiary method. But then they admit they're like, well, if they still just rely on the first confession and don't, they don't even like wait for a second confession, that's okay, even though we don't like that
Mm.
as well. But also like there's the notion that, okay, so the interesting thing about the 11th century is this is a period in which the urban militias are dominating Baghdad. So you have these urban militias known as Ayyarun are just robbing, killing members of the shurṭa. Actually, there's a point in which like one of their leaders gets so much control that like the government has to rely on him for taxation, and there's even like a khutbah made for him as well in the mosque. And so I think that like this is shaping their views as well because he actually in Mawardi actually says in a book of fiqh that on Shafi'i fiqh that uh, coercion is unlawful unless it's being done to the shurṭa, the urban militiamen
Mm.
as well. So I think that for them like there's an ethical unease, but there's a pragmatism as
Right.
well. I think that's the thing, is like where, as in like, I think the military elites and the kutab, the scribes, really do feel that this is legitimate. I think the jurists who are starting to get into this are much more pragmatic as well. Like they're much more they're more guided by pragmatic sensibilities, than ethical ones, even though they try to kind of like, the Qāḍī can't do this. Only the shurṭa can do this. And we would prefer if the coercion was given willingly, even
Mm.
if there's extra pressure.
Coercion and willingness seem to be oxymorons, but
Yeah, yeah,
um, in terms of broadening this out a little bit, why does the sort of the history of coerced confessions in particular offer us a unique opportunity to explore and better comprehend sort of the actions, logic, and motivations of non-jurisprudential actors, law enforcers, officials, all of these people who shaped Islamic law who weren't jurists?
So yeah, that's a great question, Roxana. And I think this is like what's kind of like my main argument and why I picked coercion is that, so it's a practice that doesn't emerge from fiqh. It doesn't even emerge from necessarily pre-Islamic Arabia, that we know of. And it's emerging from this kind of like it's military administrative milieu that's not legitimized by the jurists. It's legitimized by administrative classes, you know, who kind of they put in the work, right? So it's like you see the contributions. It starts out as military practices based on the actions of military elites. It's legitimized and rationalized by government officials and scribes. And then eventually it circled back where jurists who accept that, that there is the sphere of siyasa, that, okay, we're gonna legitimize this now as well. And for them to legitimize it means that it had developed to such a robust framework by that point, you know, that my argument is that actually, Islamic law is not just being developed by jurists, and the judiciary. It's also being developed by these people who we usually do not see as legal actors, but they are legal actors, and they're also legal theorists as well. Like Ibn Wahb is he is a he's a legal theorist, honestly. That whole thing that he's doing, he may not be a jurist, but he's using administrative logic and administrative continuity as well, and pragmatism to make a legal justification for these practices, you know? So I hope that answers your question.
And I mean, you kind of touched on it when I asked the question about the Ottoman Empire, but did the use of coercion during the Abbasid era influence later interpretations of Islamic criminal law? I mean, how did subsequent legal scholars engage with these practices? I mean, like, did the Mamluks go back and look at maybe Abbasid historical records, see the shorta, like, maybe they had some good ideas in how to manage their territory or empire? Did the Abbasids, I mean, did the Ottomans take any inspiration from the shorta? But I mean, you kind of mentioned that there was a
Yeah.
but yeah, just to answer my question, I don't want to waffle on.
No, 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 no. No. This is all great. So law. So I think we can distinguish between like the siyasa, sphere of law, and the fiqh law, and it's like yes to both. So it's that Barbara Johansson's article on Signs of Evidence really does this right, is that he looks at Ibn Taymiyyah and Ibn Qayyim al-Jawziyah, two 14th century Mamluk jurists who developed the concept of siyasa sharia, where they basically say that actually, coercion is legitimate, under this principle of governance by sacred law, like governance by sacred law. And what's interesting is that they'll say this can be used against urban militiamen like the Ayarur. So they're like the social, and it's like they even say that we owe a debt to Muwardi as well. So it's like clear that yes, it's that this development between the 8th and 11th centuries with Muwardi and Abu Ya'la finally legitimized it, allowed more Muslim jurists to kind of like accept this. But it was still opposed by many Muslim jurists as well. Now, for on the siyasa side of things, the Mamluks and then eventually the Ottomans are using like an administrative military approach to it. And like even like in the Qānūn Nameh of Suleiman the Magnificent in the 16th century, he justifies it as a custom. It's an accepted custom, coercing for evidence as well. So yes, definitely.
And so how does would the concept of maslaha, public well-being, also be tied to this whole concept of siyasa? Would that also be like a continuity of that just using certain methods that might be a little bit not totally outside of the Sharia, say around the Sharia, but for the public well-being of would that be a concept that
Yeah, so they're definitely like I would say Ibn Taymiyyah and Ibn Qayyim al-Jawziyya are using that. They're using it for like the public good and public welfare. They're definitely using that. I don't see that really in the Abbasid treatises
Hmm.
on this. They're not saying this. I think that's implicitly implied
Yeah,
that that's what they're saying, but they wouldn't use maslaha as like a
as an
concept
argument
or
for
as a
why.
concept for this at all. And it's like for them, I think they're like, we don't need to. It's already obvious that that's what we're thinking about this.
Trying to like bring us to like maybe the modern day, do you see parallels between the Abbasid use of coercion and how modern Islamic states manage tension between maintaining order and upholding sort of ethical legal standards? Personally, I find that the shurta give me massive IRGC vibes. But that might be my projection onto it. But do you see any parallels between how modern states manage these sorts of issues and how the Abbasids did?
So before we get to let's talk about 9/11. I mean, it's been 22 3 years, but remember, like, yeah, the use of torture,
Right.
right? Because that's the only, and their whole justification was, well, first of all, they're terrorists, so they're not like us, right? They don't believe in our freedoms, right? So, and the other second thing is that, that's the only way to gather evidence because, the urgency, something could blow up, right? As well. Now, yeah, in Iran and in Egypt and other Arab Muslim countries, like there's definitely, studies talking about the use of coercive interrogations.
For the record,
So,
it doesn't necessarily have to be within the Arab Islamic world. It
yeah,
was
no, 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 no,
just
no, no, no. But I'm just answering Roxana's
yeah,
question.
yeah,
It's more universal. It's more universal than that.
yeah,
And I
yeah,
think it's the notion. It's a notion of when you classify people that they're not the same,
yeah.
right? They're criminals, they're terrorists, that there's something fundamentally, there's a lack of humanity in them, right? They're not as human as we are, they're not as ethical as we are. And I think that leads to the fact that, okay, we can do these practices that maybe we wouldn't do with most of the population as well. But even then, so here's the interesting thing, okay? So circling back, they'll say that we're not going to use it to people that the shurṭa and like this scribes are saying this is not going to be used on people who are from good reputations. But it's not really true. They'll still like it's like they say that, and it may have been for the majority of times, but we hear about like complaints in the chronicles of arrests of people with good reputation as well. Like, so it's like they're still going to do it. And I think that's the thing is like who's a terrorist, who's like a rebel, who's against the state, right? Who's against the state, right? Like how do you evaluate that as well?
Right.
Like, what legitimate, so it circles back to the themes, right? And I think these themes are universal till today is that, what's legitimate violence, you know, and how does that, and what's the authority that actually can actually implement it, right? Is the authority something we accept? And what's truth as well? Like this is the thing is like in, throughout the administration, the American administration in the 2000s, you know, they were like, well, this is truth, right? Coercion is the truth, right? And but there's also like a lot of studies is that actually they'll just say anything
Right.
to
I
prove
mean, this
themselves.
just happened with I mean, in the hip hop world, a famous case that's happening in Atlanta where somebody that gave witness testimony to a whole bunch of things. And
Mhm.
then later it came out and he said it on the stand, like, I was just saying all these things because I wanted to get out of this situation. And
Yeah.
it totally toppled the whole case because that's what, and then, just going back to what you mentioned about how, how long of a period of time between the statement under coercion and then,
Yeah.
their next statement, how much truth is going, how much truth is there in both. And so, yeah, it's been a very interesting read your article and opened my eyes to one, coercion in early Islamic history, and the fact that we had something like a police force, which I've never heard mentioned in all of my reading of, and I'm pretty sure I've done a minuscule amount of.
Although I'll just say, Tara, like they're not just the police force. I just have to keep
Yeah, yeah.
reiterating.
Yeah, that's why I tried to say something like, because it was way more complex, and
Yeah.
I
Yeah.
wonder if there's any books that actually deal with the short. I mean, to be honest, we could have did a whole podcast on just who the shorta was.
Well, maybe for a future episode.
Yeah, yeah, maybe ideas for a future episode, because I would like to get more into them because it seemed like a complex institution
Yeah.
that definitely had a huge hand in shaping Islamic law early on.
So I think so. I'll say that I there are like so there's been like articles and like, but I think the one is that like a large amount, especially like in like written in Arabic as well, just focus on them. What they do, I think this is the trap of literary sources. We have so much literary sources, right? Because the historians like Tabari would just like write about each year. But the problem is what happens is that when you start relying, because the thing is they're not going to talk about the boring criminal cases. They're just going to talk about what's exciting, and it's going to be embellished at the same time. So sometimes it's like when you're reading this, it sounds like it's like you're reading a comic book. You're not reading like real life in some degree. It's just like the shurṭa are just like going around being, and it's like so and also I think people just miss the fact that they're a criminal justice system and just keep talking about like their police.
Right.
But one colleague of mine, Eugene Ripollard, just published a book in French on the shurṭa as well, and I also I guess we'll get into later, but that's also like the project. That's the project as well to actually write a book in English on this system because I think it's really needed because I think, criminal justice, when we think of criminal, we think of law and order,
Right.
right? So, this is like an important, if not the most important sphere of law, for us. When we think of law, we think of criminal justice. And the fact that, there isn't like, scholarship getting into this, especially in English, is why they're kind of minimized or not known, right?
And especially as it relates to early Islamic history, it seems like
Yeah.
there's a boom in people becoming very interested in what was going on, emergence of Islam, and what happened in the centuries after. And yeah, just the criminal justice aspect. We just always think that if you broke a certain Islamic law, hands were getting chopped off, and certain other things were happening. But yeah, from reading
I'll
your
tell you something very funny, how much they cared about the shurta. So you'll have stories of the prophets, like, and they'll have things where Moses gets chased by the shurta, by the Pharaoh's shurta, and they'll have stuff where Jesus was crucified by the Roman shurta as well. So it's like
they're not
then he's
hadiths
getting
where
bleeded back
the
into it, it's like that's the thing. Like, it's like, well, there's always been a shurta. They've always existed, you
did
know.
the prophet condemn the shorta
So there are like poor bit hadith of calling them the dogs of hell basically, and it's not clear whether they're the the shurta, like, are serving as dogs of hell, like the dogs of hell are shurta, or they are shurta. But it's like, but there's like things where, for example, like there'll be stories where uh somebody will say like in like a book of fiqh will say on the day of judgment the shurta will be with his whip and then he'll fall into hell with the whip as well. So it's like it's like it is a huge part of the fabric of a pre-modern Muslim society, you know, definitely. But yeah.
And what questions do you think our modern audience should ask when evaluating the ethics of historical practices like coercion and criminal justice? I mean, how can we approach these debates without imposing modern biases? Even though it seems like today is the same as yesterday concerning this, the question of coercion. I don't feel like there. Do you feel like there are any modern biases imposed on when we look at this aspect of Islamic history? Because again, I really don't see any like difference between yesterday and today in this regard.
I'll tell you something, and it's like also kind of reflecting on like recent political events as well. I think that we need to be really careful when we're studying politics and governance. This is something I had to learn in the last few years is we can't just read it as like oh they're cynical and they don't believe what they're doing. I'm becoming more and more convinced that they do believe
Mm,
what they're doing. I think it's very easy to say oh they don't believe in what they're doing and they're just doing it out of power, And to some extent it could be that, but I think more and more I'm like no, they actually there's a logic to what they're developing, and that there's a notion that they feel that they're authorized by authority, that they're extensions of God on earth, and they're pushing away the darkness through their own violence as well. But but also the thing is like just be very careful and kind of like treating like the shurta also have their limits, right? They're not like a modern state,
mm.
that they don't have the information technology as well. And they're like, I think the thing is like the government's trying to project a monopolization of violence, but there's limitations as well, right? That like it's what's kind of very interesting is that the shurta a lot of times won't prosecute all criminal cases. They'll just prosecute the urgent, the ones that are urgent that they're they're government the government authorities are telling them you got to deal with this as well. But also I think modern biases, police, right? Like I think it's like when we study these legal institutions, this is a really it's like you'll sometimes see people say the jurists are lawyers, right? And it's like you just have to be very careful on just understanding. It is a boring answer. The social historical context of these things, always, And I think we always want linearity. We want things to go straight to the present.
Right.
And there are parallels, but we have to really understand what these people are saying and not what we want to hear so much.
Right, which is why I asked the question of concerning siyasa, is that like an example of the separation of church and state? I didn't want to, because in my mind when I was reading it, I felt like it was, but I didn't want to impose my modern, understanding of things onto a period that is just totally so far removed from
Yeah,
the way we're
yeah.
living today.
So normatively, it depends on the author. So the authors, so different people would be like, no, siyasa and fiqh are aligned. And some people are like, no, they're separate. Just like the worldly and the temporal
Mhm.
as well. Like, you saw that quote from Tawhidi where he's like, he's talking about like Sunan ad-Din and uh, Ahkam siyasiya, that they're all, that like, it's like there's always been this separation. And it's actually what's kind of interesting, Tawhidi and his colleague Muskwayhi in this book of philosophy are like saying, siyasa of the kings, like, or the siyasat of the kings, always existed alongside the sharia of the prophets.
Mm.
So they're already kind of like, but is that what everybody believes? That's like a different question. But institutionally is a different matter. I think institutionally there is completely a separation on this as well. It kind of starts to close a little bit in the Mamluk period because judges start to become siyasa actors as well. But if you see like, the fact that like the Qānūn, which is separate from fiqh, as well. Like, yeah, I would say that there is a separation between governance and religious jurisprudence
Mm.
as well. But we can debate to what extent was that separation and was it monolithic?
So Dr. Alabi, this has been really enlightening discussion for myself, Terron, I know, and hopefully for our viewers as well. Your research sheds light on a really important and I think a very overlooked aspect of Islamic legal history, and I really hope that our audience has gained something from it. Before we wrap up, could you possibly give us a glimpse of your upcoming monograph? You alluded to it earlier.
Yeah.
What would it cover? When we might expect its release? It's something for us all to look forward to.
So yeah, so currently I'm working on my monograph on it's like the making of Islamic criminal justice. I mean, it's pretty evident that. So like what the article is kind of like what I'm trying to do. I'm trying to get into, what are the mechanisms of the sphere of government law, which gets over jurisdiction. How does military actions, how do administrative logic, and also adaptation of concepts form into this, also notions of authority as well, form into this, form into siyasa as well. So it looks like criminal justice in the Umayyad, the Abbasid period, the Fatimid period, and Al-Andalus as well. And the reason is that because those are so the interesting, we didn't discuss this actually, but the Umayyads of Al-Andalus and the Fatimids also had shurṭa as well. And there's actually similarities and very interesting differences between this as well. So there's continuities and ruptures. So a little interesting thing I think will kind of blow your minds, but the Umayyads of Al-Andalus, members of the jurists were heads of the shurṭa.
I was thinking about, and I wanted to ask a question about Al-Azai. Was he the jurist Al-Azai? Would he be considered? Because I know a lot of the Syrian troops were influenced by his jurisprudence.
Yeah.
And I understand that the shorta came from a military administrative way of doing things. So I just wonder, how did the Syrian jurist Al-Azai kind of fit into the shorta?
So actually, a better person to look at is Ibn al-Zuhri,
Ibn
basically,
al-Zuhri, okay.
yeah, because he's involved with the administration of Hisham ibn Abdul Malik, and he's writing fiqh as well. And apparently, he was a Sahaba shurta. I don't know how true that is. That's what a literary source says, but I wouldn't be surprising, right? Because it's there wasn't the separation between the military elites and the early jurists and the judges at this point, right? So to build on that, this is kind of my argument. My argument is that the Umayyads of Al-Andalus is kind of this continuity where there isn't that separation, like there is in the Abbasid period as well. Because it's you'll see biographical dictionaries they'll be talking about jurists, and they'll say they were heads of the shurta as well, and they'll mention oh, this guy was a Sahaba shurta, and he was narrating traditions and stuff. It's just completely like different as well. But also it's southern Spain, Iraq, and Egypt are also these cosmopolitan cities as well. So they had to build this administration of the shurta as criminal justice as well. And so I'm looking at kind of like a comparative angle of this, but also I'm looking at how does criminal justice form, and why does it form, so that's basically what the book will be about.
Okay. And also, where can our audience follow your work and stay updated on its progress, or any articles that you release?
So I'll say this is that, funnily enough, I have an article coming out next year. It's completely has nothing to do with Islamic law. Actually, it has to do with it's a co-authored article on a comparative look at Ibn Khaldun and a Italian historian, Giovanni Villani, and how there's a cross transmission throughout the broader Christian and Islamic Mediterranean understanding of each other during the wave of the Black Plague and a war happening in North Africa as well. So just to say is that I'm not one trick pony. I don't only focus on Islamic law. I got a wide variety of interests as well. But yeah, I'm working on 2 articles, one on the origins of Tazir, and also one on caleful discretionary judgment as a source of law and criminal justice as well. So hopefully those things will come out soon. But also, if readers want to get some more, they can look at I actually wrote blog posts for Harvard Islamic Law blog as well, and they can give you kind of an indication of what I'm going to be doing.
Okay, well, make sure to share that in the description for
I will
check out, definitely.
Yeah.
All right, and yeah, again, thank you so much for joining us, Dr. Al-Lehbi. It's been a pleasure going over your fascinating research, and we look forward to your monograph as well as your other upcoming articles that you have in store, and whatever future contributions you have to the field. And to our listeners, thank you for tuning in to this episode of the Real Talk Podcast. Be sure to check out Dr. Al-Lehbi's article. It is permitted for the Amir, but not the Qāḍī. And stay tuned for updates on his upcoming monograph. Until next time, peace, everyone.
Thank you
And
guys so much. I had an
of course,
absolute
and we hope to have you on again for if not your monograph, we'll check out your articles, and maybe we can put something together.
Yeah, no, that would be totally great. And thank you so much, guys.